Good afternoon, everyone. My name is Becki Young, and I'm a partner at Grossman, Young and Hammond in Washington, D.C. And I'm very pleased to be with you here this afternoon. We have a very distinguished panel of immigration attorneys who are here to talk about O-1 agents. You can judge for yourself, but I think we have a tremendous depth of expertise here for you. So this meeting is being recorded. If you don't want your likeness to be recorded, please turn off your camera. I will also ask, because we do have a big group, that you put any questions in the chat. We'll do our best to get to your questions. We have about 45 minutes of information to provide you, and then about 15 minutes at the end for Q&A. And I'm going to be moderating. We have here with us today Jonathan Ginsberg, who has a fantastic context that he can provide us about the O-1 visa and how it all came about, some congressional experience to share with us. We have Matthew Covey from CoveyLaw, and also Tamizdat, who has a really interesting story about how he got into O-1 visa work. And my colleague Denise Hammond from Grossman Young is also here with us today. So let's go ahead and get started. I would turn it over to Jonathan, who's going to sort of set the scene for us and explain to us his experiences with O-1s, how it came about, and any other context that he would like to provide us as a backdrop to our talk today. Take it away, Jonathan.
Hello, everyone. So I got involved in this whole topic because a partner of mine happened to be general counsel to what was then the American Symphony Orchestra League, which later changed its name on account of the unfortunate acronym. But, and the league had just noticed that Congress had passed an immigration bill that seemed to make it extremely difficult for individual performers to come to the US. It was very concerned. I had just started my immigration practice. This is in 1991. Well, I'd started it a bit earlier, but I was going full time at that point, and I took a look at the what had happened in Congress, and lo and behold, in the late night, first the House and then the Senate, just before a Thanksgiving break, had passed a law that seemed to raise the standard for approving O visas for performers to a considerably higher level than it was at the time under the H-1B regs. So eventually I wound up representing a very broad coalition of management agencies, performing arts institutions, a wide range of venues, individuals, you name it, and coordinating with a great many more who weren't formally part of the coalition to go back in and see what we could do to change the O standard and to moderate and modify some of the other provisions. Eventually we succeeded after lengthy negotiations with organized labor on the one hand, and then doing our best to influence the reg making process by then INS. But the one topic that no one really addressed at the time was, in fact, the existing H1, which was carried over to H1B, description of agents and managers to the extent that they were described. So what came about was that INS at the time issued a draft set of regs to which the entire field responded. the number of comments was extraordinary during the reg making process. But the description of agents and managers wasn't really a topic of great concern, because everybody kind of assumed that one way or another, those who had been filing petitions could continue to do so. And that's actually proven to be the case. The problem was that the agency itself really didn't understand the field of representation, because it was kind of unique to the entertainment industry at the time. And so the net result is that you have a rather academic description in the regs of all the various permutations of agents and managers, but without any real understanding functionally of how they interact with the field, and what they do and what they don't do, and what they'll be responsible for and what they won't be responsible for. That confusion has never been cleared up. And so the net result is that we have to sort of take a fine slicer to the regs, and for each permutation, we have to figure out what documentation you need in what circumstances. As a practical matter, at least for those of us who've been working this field for a long time, the confusion hasn't proved to be an impediment. But the danger was always that new, now CIS agents, relatively untrained, and in any event who didn't gain any further insight during their training into these relationships, that they would impose unfortunate, unnecessary, uncalled for requirements, documentary requirements on petitioners, by virtue of the fact that they couldn't really understand what the petitioner's role in the process and in relation to the beneficiary or beneficiaries would be. So over time, the agency, well, it issued a rather unfortunate memorandum, as I recall, in something like 2009, a Don Neufeld memo that further confused everything. And now it has some information in the policy manual. There's a Q&A in the description of the O-1 classifications separately on the USCIS website. But really, no one has gone through and tried to eliminate language, which is what really needs to be done, because there's too much description in there for the subject matter that they're attempting to describe. It's simpler than it appears to be, as best I can tell. And I in my practice, I never had a problem with defining, identifying, or using agents or managers as petitions in a wide range of circumstances. I just never had, to my recollection, an RFE on that issue. Had plenty of RFEs, but not on that one. So with that, I think let's leave it to the discussion. That's as much of a history as is relevant to this, and let's move on from here.
Wonderful, and thank you, Jonathan. I'm trying to remember whether we've gotten an RFE on the issue of agents, but I know that the reason that we decided to offer this webinar was that we had a case with a really interesting agent issue, and we spent a lot of time dissecting the regs and trying to figure out what the rules were for an agent, actually in a non-artist and O-1A context. And we felt like Denise is going to talk about that case and the research that she did just to try to understand, as a very experienced immigration lawyer, what the heck are the rules with regard to agents. So please go ahead, Denise.
Right, and I had an RFE on the agency issue. So what happened was we took on this pro bono O-1 for an African human rights crusader. We were approached by an NGO in DC that collaborated with his employer and wanted to, employer in Africa, and wanted to bring him to the United States to raise awareness about human rights abuses in Kenya, his home country. And his extraordinary ability was clear, but we got into these agency issues because the NGO, while they were willing to file, did not want to employ him. They didn't want that liability or that responsibility. And so we had these issues, well, who was going to pay him? And could he lecture at universities? Could he receive stipends? And so we dived deep into those issues, and we wound up filing it as the NGO acted as the US agent for his foreign employer. We got an RFE on the agency issue, and not on the extraordinary ability, but on the agency, and they requested a more detailed itinerary than we provided, which in my opinion was incorrect. And we clarified it, we gave them what they asked for, and eventually it was approved and he arrived in the United States earlier this week. So that was a happy ending. And so out of this research, we thought it would be a good idea to share what we learned, what I learned, even though I've been in practice for many years. It was the first time I've come up against this issue. We thought it would be interesting for business immigration lawyers and others who might want to take advantage of these agency filings and to incorporate the institutional knowledge that Jonathan and Matthew and Becki bring to the table. And so, Christine, if we can go to the next slide, we have just a list of some helpful resources. It includes the memo and the Q&A that Jonathan just mentioned, which I'm not going to go into in the interest of time. And then if we can go to the next one, this webinar assumes basic knowledge of O-1 practice, but I just want to highlight a couple of concepts that are important for the agent petitioner context. The first is the difference between O-1As and O-1Bs. O-1B cases can add performances or activities to the event without amending the petition, provided, it requires a person of extraordinary ability. O-1A cases require an amended petition. Second concept is the definition of event. It is broadly defined and supposedly flexibly defined. It includes incidental and related activities such as promotional appearances, short vacations, and the like. Finally, like all non-immigrant petitions, the O-1 must be filed by an importing employer. There is no self-petitioning. And if we go to the next slide, we'll take a closer look at who can act as an importing employer. There are three categories. First are US employers, second are agents, and third are foreign employers acting through a US agent. So as somebody who was fairly new to this, I was trying to wrap my arms around, well, when would you use an agent and when's it useful, when's it required? Well, O-1s can't self-petition, but there are a lot of self-employed workers who otherwise meet the O-1 requirements. So an agent is good in those cases. Agents are also useful who represent workers that arrange short-term gigs with multiple employers who would otherwise have to each file concurrent petitions, which is obviously extremely burdensome. And finally, foreign employers must use US agents to file an O because they're not amenable to service of process in employer sanctions enforcement cases. If we go on to the next slide, we can look at this obvious question, well, who can serve as an agent? And
Denise, I apologize for interrupting you. You may be getting to this, but I think it's really important that we explain that an employer in the O-1 context doesn't mean what employer usually means, and agent doesn't mean what agent
that's exactly right.
really
And
means.
we're going to cover that in just a second.
Okay, very good.
So who can serve as the agent? All right. Any person or any entity can serve as the agent. It can be your neighbor, a friend, a relative, or a booking agent, right? Compensation is not necessary. An agent can be a music publisher, for instance, that files on behalf of venues that have contracted with a performer to provide a variety of services. An agent can be a corporation that files on behalf of a CFO for a 3-year term, but also files on behalf of other companies so that the beneficiary can sit on their boards of directors. The agent simply has to be authorized to act on behalf of those end users or the beneficiary in the limited context of the O-1 petition. It does not have to be in the business of a booking or management agent, which is a very common misconception. A petition filed by an agent has got to meet basic evidentiary requirements and then some special requirements depending upon who the agent is representing. And if we go to the next slide, we'll look at what those basic evidentiary requirements are. Christina, can we go to the next slide? Right. So there are 4 evidentiary requirements that apply to all O petitions. First is the evidence specified in the classification, whether you're O-1A or O-1B. Then you need the written advisory opinion. And then you need copies of, quote, any written contracts between the petitioner and the beneficiary. If there's not a written contract, it can be a summary of an oral agreement. It's just got to show what was offered and what was accepted, and it doesn't have to be signed. And the final basic requirement is for an explanation of the nature of the events and the start and end dates and a copy of, quote, any itinerary, the implication being if there is none, then none would be required. Let's drill down on the next slide on the itinerary requirement. All right, again, if there is an itinerary in existence, it must be produced. Another provision in the regs require an itinerary when the services are supposed to be performed in more than one location. All right, and then on top of that, there are special itinerary requirements depending upon what hat the agent is wearing, who they're representing. And the purpose of this requirement of the explanation of the nature of the event and the itinerary is to prove the existence of work, the type of work, when it's going to occur and where it's going to occur. Because even though there's no wage requirement in the O-1 context, it is not for speculative employment. And that is, I think, the source of a lot of confusion among adjudicators and RFEs. Now, the itinerary can be flexible depending upon the industry standards. So the guidance says that for a fashion model, for instance, an itinerary that says he or she is going to model many times for designer X from March through September, that could be a sufficient itinerary. Of course, you want to include any evidence documenting the proposed performances, such as brochures, ads, and the like. And as I mentioned earlier, you want to cover any incidental or related activities and build those into your itinerary. Now we want to look at some special evidentiary requirements depending upon how the agent is functioning, who it's representing. And this gets into, Becki, your earlier question, who can the agent represent? You have the agent that represents multiple employers. All right, that's like the music publisher or even a booking agent that's going to represent multiple venues with whom the beneficiary, the artist or the performer, has contracted to provide these services. Well, in that case, the regs say the agent has got to be, quote, in business as an agent. And to Jonathan's point about overcomplication, all that means is that the agent must prove that it is authorized to act on behalf of those end users. In those cases, the petition has to include a fairly detailed itinerary, dates, names, and addresses of actual employers, those end users. It's got to include those contracts that the performer has made with the end users. And then it's got to include the proof of authorization to act as an agent. And again, compensation isn't required, but it could be helpful. Now let's look at the requirements imposed when an agent is performing the function of employer. All right. This is a situation where the agent exercises a certain level of control and exclusivity over the beneficiary's career. It's not a traditional W-2 employment relationship. It requires a contract between the agent and the beneficiary, laying out the terms, again, to prove the agency that it's functioning as an employer. And going back to those basic requirements, the petition has to include any itinerary, but the detailed itinerary is not required unless, going back to the other provision we discussed, the services are to be performed at multiple locations. All right, and the contract between the performer and the end user aren't required because the end user are not the performer's clients, they're the agent's clients. Okay, an interesting illustration of the difference between agents functioning as employer and those representing multiple employers is in this AAO case that is cited there on that slide, this unnamed case, where you had a modeling agency that filed a 3-year O for a very sought after model. And their contract said that the agency would negotiate and collect fees for the model, make the assignments, and it also had an exclusivity clause. The model had to work with that agency and could not work with others. And it said that they did not have an employment relationship. So the agency took the position, the modeling agency, that it was functioning as an employer and not representing these other end users of the model services. And it submitted a fairly general itinerary, couple of select clients and a couple of future fashion events. And it also included proof that modeling assignments are made on very short notice and that they really don't lend themselves, that industry, to a fixed itinerary. So the Vermont Service Center said no, they denied the petition. And they said, you can't be functioning as an employer because your contract specifically disavows an employment relationship. And the AAO took it upon itself and said, no, this modeling agency is functioning as an employer because it exercises some control and some exclusivity over the model. Therefore, the end users are the agency's clients and not the models. So then the AAO said, well, so do we need a detailed itinerary here? We only do if the work is going to be performed at multiple locations, multiple work sites. And the AAO looked at all the proof about what goes on in the industry and said these assignments are too short and fleeting. They borrowed from DOL concepts in the H-1B context and said, these are not work sites. The only work site here is the petitioner's address on that petition. Therefore, you don't have multiple work sites and you don't need that detailed itinerary. And then we'll look at the next slide on the third general category of agents that impose special requirements. And that is for US agents filing on behalf of the foreign employer. This is a pretty simple and straightforward case. You've got to submit proof that the petitioner is authorized by the foreign employer to file. A one-line statement is sufficient. The agent has to agree to accept that service of process in employer sanctions cases. And incidentally, it's interesting that the foreign employer can be owned by the beneficiary. So just an interesting point. And then we will wrap up with the obligations of all agents. They are required to certify the accuracy of representations under penalty of perjury. They have got to file amended petitions where there are material changes. And remember that O-1A and O-1B distinction. They share joint and several liability for early termination, for transportation costs on early termination, and they're responsible for complying with 274A verification requirements. So that's basically my attempt to distill down what these regulations say. And with that, I'll turn it over to Matthew, who has some very interesting story about his career and some additional insights into these paradigms.
And actually, before Matthew, if I may, just 1 second, I wanted to underscore 2 points that Denise made, because I think for me, the two most important takeaways about O-1 agents are, whenever we use the word employer, we're not talking about, as lawyers, we think an employer directs and controls the work of the employee, issues a W-2. In the O-1 context, the word employer has a completely different meaning. So, please disassociate yourself from the traditional idea of employer when you hear us saying that word. And by the same token, an agent, we traditionally think of an agent as someone like William Morris, which is not what an agent means in this context. So the last slide that Denise just showed us explains exactly what an O-1 agent commits to, and that you don't see anything about what William Morris does on that slide. So it's really important when we think about the word employer and the word agent to remember that those are very specialized terms in the O-1 context, and we shouldn't ascribe their normal legal meanings. And I think sometimes there could be ethical implications to these words, which Matthew is going to cover, but I just wanted to highlight those two concepts, which I think are really important. So thank you, Matthew, and we'll let you take it from here.
I think I'm going to cover the ethical ones. I'll give it a try. Or at least we can loft the topic into the Q&A, and we'll go from there. In 1991, when Jonathan was haggling over these in DC, I had just finished grad school and was teaching literature in Slovakia, a position which eventually was occluded by getting myself into a punk band and spending the better part of the 90s touring in Europe and then eventually in the US. Somewhere along the line, the individuals that the artists that we were playing with in the recently, this is just post the Berlin Wall coming down, in the nascent music scene of Eastern Europe. We got very involved with the community of artists there and trying to figure out ways to leverage our contacts in Western Europe and back in the US to help the artists that we were working with there, and friends mostly, get to be able to tour in Eastern Europe and in the US. One of the things we found very quickly was that in the mid-90s, while the Elton Johns of the world were all getting their visas properly and coming into the US to do on their O-1s and their Ps, there was a huge subclass of artists, dancers, actors, musicians, who were coming from Western Europe and were not getting visas at all. They were coming in as tourists because they didn't understand or couldn't afford to work their way through the O and P process. Problem for Eastern Europeans, and it became clear to us ultimately for everybody, artists from throughout the rest of the world, people who didn't have ESTA, weren't able to sneak in on ESTA, was that the US was a really unattainable market and audience group for a lot of those artists whose tours were not profitable enough to, and who didn't have the administrative support to get them through the visa process. So a lot of artists from Eastern Europe, Africa, Asia, South America, just weren't coming to tour in the US, not because they didn't have fans, but because, or viable tours, but just simply they couldn't overcome the bureaucratic burden. So somewhere in the mid-90s, the three members of the band that I was in formed Tamizdat, became the three original directors, as a nonprofit aimed at trying to figure out ways to help independent, non-commercial artists legally thread their way through the US visa process. Initially, we were primarily working with artists that we had worked with directly. We were helping booking those tours. And this is long before I was a lawyer, and then eventually figured out how to prepare and file an I-129 petition and act as the petitioner. And then through a non-legal but careful reading of the regs, realized, hey, wait, there's this agent thing. We could represent all these different venues. We could do that. So one thing led to another. We ended up working with more and more. Somewhere along the lines, we realized, wow, this is really a lot of work. I wonder if we could charge somebody for this work. So eventually we started charging a small fee to help to provide this administrative work. Always acting as the petitioner for the artists that we were working with. Somewhere along the line, I went to the APAP conference in New York, and there was this immigration lawyer there who was spreading great amounts of wisdom to a round table of agents and presenters. And I sat down and introduced myself to Jonathan. I said, Jonathan, so it's really great to hear what you're saying. This is what I'm doing. I've got this nonprofit. And he got this big grin on his face. And then it led to a really fascinating, long conversation that's gone on for some 25 years now about the role of agents and petitioners and the relationship between agents and employers. Excuse me. So fast forward to the present, Tamizdat has now acted as the petitioner, as the agent petitioning on behalf of somewhere around 50 or 60,000 performing artists since then, and continues to is not involved with the actual preparation of petitions at this point, just simply acting as the petitioner, doing a degree of due diligence on the artists, and accepting that responsibilities that have already been outlined as a petitioner. We see it as being a really important facility because a lot of the artists we work with do not have a US entity that would be willing to take on the role of being the petitioner for them. They don't have an agency or an agent that is sophisticated enough to be the petitioner, or they're working for a whole series of different venues. They're doing a tour with venues, and none of those venues have the sophistication to take on that project. It also is useful because a lot of times when artists earlier in their career get themselves in a situation where they where they're working with an agent, and but their careers are still very fluid, where they're moving from one agency to another. They're just starting to get their careers set up in the US. Maybe they're not working, maybe they have got several different labels that they're working between. And were they to use one of those agents or one of those management companies or one of those labels as their petitioner, in some ways, depending on how the petition's filed, they may be stuck with that artist or that entity for the duration of their visa, which is limiting from a career standpoint for a lot of artists. So having an agent, having an entity acting as an immigration agent on behalf of multiple employers is one way that artists can remain more in control of their careers. So I just want to run through changing hats here as an immigration attorney now many years later, when I'm preparing an O-1 petition or P, because I think this pretty much the rules for agents with O's pretty much parallels the rules for agents with P's. The first thing we try to figure out is what is the authority under which this petition is being filed. And the authority determines the kinds of documentation that's required. So I would want to mention, obviously, the actual employer. So that's when the entity that is actually paying, and we might have a W-2 situation, or we might not, but regardless, we have a U.S. entity that's actually employing, and that's the most simple authority to work under. Then really you need the contract between the petitioner and the employer. Denise, you said that contract doesn't need to be signed. Legally, you're right. Practically, I'm not sure I'd agree with you on that one. We have had RFEs with officers coming back saying this isn't signed, and it's easier to get it signed than to fight the RFE. So if you can get it signed, I would. In the entertainment world, often contracts never get signed, and that's always a challenge for CIS to understand. With an actual employer, you need the contract between the petitioner, which is also the employer, and the beneficiary. And as you said, you need the itinerary. Actually, but that's only if the beneficiary is working off-site. Otherwise, you don't need an itinerary, and that's one of the great advantages of that. So as you said, the question of what constitutes on-site and what's not, but generally you're not going to see CIS RFEing a petition that is lacking an itinerary if the petitioner is the actual employer. The agent performing the function of the employer is a massively useful way of structuring a petition, though it is very confusing to certainly it's a hard authority to work under when you're dealing with larger institutions, and there's a lot of questions. We often get pushback from major entities who don't understand how that works. When the petitioner is an agent performing the function of the employer, again, you need a contract between the petitioner and the beneficiary. In this case, that contract is really just the authorization, the beneficiary authorizing the petitioner to act on their behalf. And then the contract between the agent that's performing the function of the employer, and the beneficiary. In that situation, you're right, Denise, there is a fair amount of flexibility that goes into what constitutes the itinerary. I would not file a petition where the agent is performing the function of the employer without including some itinerary. They're going to want to see something so they can check that box. I really wish it wasn't the case. And to me, that's sort of a holy grail, is to reach the point where the itinerary could simply say, this artist is coming to work pursuant to a contract with this booking agent. And that's it. That's for 3 years. That's all you need. But they're not to that point. CIS is going to RFE that, or at least most agents would. Most officers would. And they're going to want to see some outline of what the artist plans to do under the terms of that relationship with the agent. Now, the interesting thing, historically, there's been a huge problem with itineraries, because for many years, booking agents tended to fabricate dates and create elaborate itineraries that were completely fictional. And
Matthew, that's sort of where the ethical issue comes in, I think.
Yeah, it was not really an issue there. I think it's fraud.
Yes.
So it's pretty clear cut what's going on there. The confusion was, of course, that it worked for the vast majority of the time. CIS didn't care or didn't notice, didn't look up and realize that most of these tour routings, as often as not, didn't make any sense. Oftentimes the venues were closed. It's appalling what we got and sometimes still get from agents saying, well, you know, I want a 3-year O-1, so here's 3 years of dates every 2 days for 3 years. Obviously, that's not going to happen. So how do you get from, well, you got a potential 3-year, which any artist is going to want, so they don't have to go through this whole petitioning process, you know, repeatedly. How do you do that? But how do you not file something that's fraudulent? How do you accurately represent what the artist is going to be doing over the next 3 years, even if it's based on the relationship with their agent? And what we have found is, especially when filing a petition under the authority of the agent performing the function of the employer, you can be pretty open about it. And the more transparent you are with CIS, the tendency is the better they respond to it. If you've got solidly confirmed book dates, include them. Probably don't include the contracts for those dates, the performance contracts, because that's going to confuse them. If you've got an agency contract and then you include performance contracts, they'll get all confused and be like, wait, what's going on? But include contracted dates. And then if you know, so for example, oftentimes we'll have an itinerary which will say we're filing right now, it might be November, December, January, straight up itinerary, addresses, guarantees, dates, times, load in, all that stuff. Then as you move deeper into the future, it tends to get more vague, but always referring back to the fact that these plans in the future are pursuant to the contracted relationship with the agent that is performing the function of the employer. The other thing that's really critical, and a lot of times people are told that you can't have a gap of a certain amount. And I think that's advice that I worry about, because I feel like telling an agent that you can't have a gap of more than 60 days is inviting fraud. And because they're going to just take that as a rule and they're just going to make up dates that, every 60 days for the next 3 years. I think a much better way to approach gaps is to make sure that you're doing a really diligent explanation of what the artist is doing if they're not in the US. And that we have found is really an effective way of addressing gaps. We have filed many petitions where there might be a year gap between engagements, but as long as we explain what the artist is doing outside the US during those 364 days, and remember, it has to be, the activities outside the US have to be related or incidental. And honestly, I have trouble imagining anything that wouldn't either be related or incidental. I mean, having lunch is incidental, related is recording another album. Like all of that, it's a pretty open category. Detail that in the itinerary. As long as that's detailed, the chances of getting an RFE are, even on a large gap, I think in our experience has been small. And over the last 15 years, it's gotten smaller. Agent representing employers, the regs say multiple employers. It's become pretty clear that multiple employers doesn't really mean multiple employers. It means employer or employers. You can have an agent representing a single other employer. I think we got an RFE once from California that said, wait, it says multiple employers and there's only one. And we pushed back and we won. But I think it's important to realize that you can be multiple employers or single employers. The agent can represent either one. In that case, it's effectively the same documentation that you need, except obviously, unlike with the agent performing the function of the employer, you don't need the contract between the employer and the beneficiary. You just need to demonstrate that you need to show the authorization by the employers that the agent has been authorized to file that petition. Agent representing a foreign employer is really the same as agent representing multiple or single other employers. The only difference is that the authorization has to specify, the foreign employer's authorization has to specify that it authorizes the US employer to accept service of process. Otherwise, agent representing multiple employers is the same as agent representing foreign employers. As Denise mentioned, it's very interesting that it's become clear in recent years that that foreign employer can be the beneficiary's own company, which is fascinating given that you can't self-petition, but you kind of can if you need to through that route, if your beneficiary is willing to set up an entity abroad. Then there's the kind of quizzical last one that we include, which is actual employer and agent representing employers. The situation like this we run into a lot, although it may sound kind of obscure. It's the basic situation is where you've got a major venue or festival that is the principal anchor gig on a tour, and then supporting that, they have arranged with other venues around the country. For example, there is a coalition of world music festivals in the US, and they all block book together. And usually one of them takes on the role of being the anchor for an artist that they're bringing in for that circuit. They'll make sure that they've got the biggest guarantees, they're going to handle the flights, and they're going to handle the visas. But they're block booking with their colleagues at other world music festivals around the country. So they'll be the petitioner, they'll be the actual employer because they're actually bringing the artist and the artist is performing for them. But then they're also representing, for the purposes of the petition, the other venues that they're collaborating with on that tour. I wanted to say one quick thing. Am I out of time? Am I running over yet?
You're good. I guess, we should tell folks, if you do have questions, you can feel free to put them in the chat, and we'll let Matthew wrap up, and then we'll ask the panel to address any questions. But please, Matthew, go ahead.
I just want to say two quick things. One, I think that there's a little bit of debate. Obviously we're always trying to push the limits of how broadly you can interpret the rules of the role of the agent. And oftentimes we butt up against legal departments at major corporations, major entertainment corporations, who their tendency is to interpret these rules as narrowly as possible because they're trying to make sure that they're covering their clients' interests. And those are always interesting conversations. And one of the conversations that comes up and I don't think it's addressed in the regs, is, the O-1 says that the rules say that for artists and entertainers for the O-1B, you can add other engagements after the petition has been signed. So the question that comes up is, does artists or entertainers mean anyone who's on an O-1B? Or is there a subset under O-1B, which is artists and entertainers, for whom this rule applies? That's not resolved in the rules, but if you've got a graphic designer, or if you've got a creative director that you're doing an O-1A or an O-1B for, can you set up the petition? Is it allowable to add additional engagements after the petition is signed, filed without filing an amended petition? That's an unanswered question, I think. But I will say that we've never had a problem with it. We've never had an issue where CIS has pushed back against it. We've had lots of corporate lawyers push back when we try and convince them that it's going to be okay, but we've never had a problem with CIS doing that. I think that was the only comment I just wanted to make about, in regards to that. I think that's about all I have to say.
Matthew,
Yeah.
let's not neglect university general counsel's offices, which are particularly obdurate.
Yeah, that's a huge problem that we feel like. Well, years ago, I got Jonathan to write an opinion letter for us about why it's fine for artists to add dates on their itineraries, because invariably when we have an artist performing at a university, we get an email from their legal or accounting department saying, wait. This gig wasn't on the itinerary. We were not the petitioner. We can't pay this artist. And then we have to have a long conversation. but that's kind of a running conflict, I think. You're right, Jonathan. Universities are challenging in that way.
Well, and I was actually going to ask, I think probably a related question. I remember, and actually I have one quick comment too. You had mentioned, Matthew, that with regard to the actual employer scenario, that you had not gotten an RFE about itinerary, but we actually have gotten an RFE about itinerary. And so in all of our actual employer cases, which are probably 90% of our O1 cases, we have a section that says the itinerary is this person is going to be working as a full-time W-2 employee 40 hours a week at this place for the next 3 years. So that's the itinerary, but we address it in every case because we have been RFE'd on it multiple times.
It's safer to do it than to have to deal with the RFE, although it's frustrating because when you do that, then you raise their expectation that, oh, you should always get an itinerary. And then when somebody pushes back, it gives them mixed messages.
It's agreed. But sometimes it's better just not to fight. We have a question here from Tiana. She says, in the scenario, she said, can the scenario with an agent representing employers work for non-artists, for example, a talented lecturer who would like to come to the US once a month as an O1A beneficiary to teach lead master classes in finance or banking? So could that be done as an agent representing employer? Anyone can take that question.
I'm going to hazard, I don't see why not, as long as it's all, because it's an O1A, all of that would have to be on the itinerary. There wouldn't be any flexibility after the petition's filed, but I don't see any reason why that would be a problem.
Yeah, I would agree. I mean, I think unfortunately, you can't add related events for O1As, but as long as you could map it out, we've definitely done cases like that before. Daniela wants to know about recent RFE trends where USCIS is performing a public records search and questions the agent's ability to do business. I have not seen that one before. Matthew, you probably do the most O1 petitions of any, I'm sure you do the most O1 petitions of anyone here. Have you seen that?
Well, when Tamizdat's acting as a petitioner, we don't, because I guess at this point they're used to us. I have seen that. That seems to happen. Jonathan, you're going to be able to speak to this more than I can, but I feel like that kind of RFE tends to happen in August and September.
Unrelated to vacation schedules, I'm sure.
And unrelated and tends to sort of parallel those kinds of RFEs where suddenly you see H-1B language showing up in an O1, RFE. I think it has to do with training and officers not understanding either exactly how the O1 works or how it has come to be used. The former is sort of inexcusable. The second is excusable if there's ways that the industry has come to rely on it that aren't exactly clear to in their training. Jonathan, I'm sure you got.
I mean, my reaction is the same. They also may be pushing more petitions out the door to meet some basic numbers requirements, in which case they're getting sloppier and sloppier at the end of the fiscal year. But my reaction to that one would be I'd respond by saying it's beyond your purview to determine whether the agent is able to do business. We have established that there is an agent and the agent has the requisite authorization. That's all there is.
Yeah.
I mean, anything beyond that, then you get into a whole, hall of mirrors on, well, how do you know who is who and how you know who can do what? And you can pull that all the way up and down the chain. And you can ask for evidence of, the existence of the universe by the time you're done. I mean, it's a pretty slippery slope once you get to the point where you're trying to figure out whether somebody who simply is filing a petition is somehow able to do X, Y, and Z.
Right.
You can also cite to that AAL case, which has a very detailed discussion about common law agency principles.
Yes.
And how limited they are. and how basically it depends simply on proof that, as Jonathan said, there's authorization to transact business on behalf of the entity.
Well, and I think we will be sharing the slides for this presentation after the fact, and the very last slide that Denise shared with the 4 duties of an agent. If I got this RFE, I might just pare it back and say, this is what the regs say an agent can do. We've showed you that the agent can do this. You don't need to know anything further than that. And we've fulfilled the legal requirements. Matthew, there's a question from Colleen about what work do the artists do for Tamizdat. Do you want to address that?
Sure. I think that's a really good question, and it's something I think it's important to talk about. But this goes back to, what does an agent do? And again, are we talking about a talent agent? In which case, what the work that an artist does for a talent agent, well, that's confusing, because usually the contract between the artist, a talent agent's contract is actually between the artist and the venue usually. So what work does the artist do for the talent agent? Well, they are executing the contract that the agent got for them, but there isn't really a traditional employment relationship, but the agent is taking a commission on that. So in that situation, there's arguably sort of work being done for the agent, for the talent agent, by the artist. In the case of an employee, of an immigration agent, someone who is authorized to act on behalf of the artist for the limited purpose of immigration, there isn't anything that the artist needs to do. There isn't anything that needs to be done for, in this case, Tamizdat. The agent functioning as an immigration agent doesn't have to necessarily get anything out of that relationship. I hope that answered the question. I don't know.
I think that's a really interesting point, though. I think that's why it's sometimes hard to wrap your head around it, because we want to see a quid pro quo. And, the agent does, the immigration agent does take on certain obligations, such as accepting service of process. Correct me if I'm wrong, Matthew, but the agent may be responsible for the return transportation obligation.
Could be. We've never actually had to do that. But theoretically, yes, you are
right
doing that. But I think, Colleen, to your question, part of, as a nonprofit, part of the, Tamizdat doesn't charge to do this service. And that's part of the reason it doesn't, is to just be really clear that this is something it is doing for the furtherance of the arts, and that's one of its programs. But that's maybe immaterial to your question.
But that's great, and we all benefit from that, and we appreciate all the artists that you guys have brought to the U.S. All right, we have one last question from Catherine Haight, and she cites to the regulations here, which say that an agent may be one of the listed options. We talked about these various options. She says, do you agree that the fact that the word must was not used means an agent may be something or someone else? Jonathan, I don't know if you have any opinion on that, the use of the word may versus must in the regulations. Okay, and actually, while you address that, I'm going to read Fabrizio's question, which may be related. But what do you think, Jonathan, about whether the agent, the definition of agent could be more expansive than what's listed in the regulations because they use the word may?
I think that I'm having a hard time figuring out what other scenario there is besides the ones we saw earlier. But I don't think that the may, I think the may in that context it actually means must, in the sense that they're saying agents, or they could have said can be, or are one of the following, because I think I suppose it's possible that there's yet another scenario for agency, but one way or the other, I'm having a hard time figuring out why you can't fit within one of the enumerated categories. So I'm not sure that the distinction between may and must in this context is particularly relevant. Just if you're being especially punctilious about your description of agency in the petition, then what you would do is explain why you fit within one of these categories. Kathy said, for instance, representative of only the beneficiary. Well, an itinerant performer coming in from abroad contacts a friend, okay, and says, can you be my agent for immigration purposes? So friend puts together petition. Petition includes something from the beneficiary saying, I appoint friend as my agent for immigration purposes. Now, this friend resides in the US. Is that sufficient to establish agency? Yes. Is it all the documentation you might need in the petition? Absolutely not. You still need some underlying documentation of the itinerary in that case. Go ahead, Matthew.
This brings up an interesting question, and I think this goes back to Becki, your question about ethics. When as an attorney, if you're preparing a petition on behalf of, say, only the beneficiary, I personally think there's a problem, because any petition, you have two clients. You've got the employers and you've got the beneficiary. And we obviously have an engagement agreement with the beneficiary, but we also get an engagement agreement with the employer as well. But I know not everyone does, and I know that because oftentimes when we're working with like a major record label and we say, hey, you're engaging us as lawyers to file this petition, we often get a lot of pushback from a record label saying, well, we've never signed that engagement agreement before when we filed a petition. Why is that? So I think there's an ethics question there for our community, is whether that engagement is something that really needs to be papered or not. I'm not sure.
Okay. We have two interesting questions. If the panelists have a few more minutes, I'd love to stay on to address them. If anyone needs to leave us, we certainly understand. I want to take Victoria's first, just because I have some thoughts about this. She asked if the definition of employer-employee relationship is not as strict as an H-1B, then so long as the employer retains some control over the worker, is it okay if the employment contract states the worker is strictly a contract worker, no agent is being used, the petitioner is the employer? It's my understanding, but I would love to hear if anyone has another thought, that that's totally fine. The O-1 can be an independent contractor. There's no requirement even of, I guess there has to be some control because there's a contractual relationship, but it's not the traditional direct and control concept of an employee. There's no requirement that you have any sort of traditional employer relationship. Matthew, do you have something to add about that?
I would agree with that.
Okay. All right. So last, Fabrizio asks about the early version of the O-1 regulations, which he understood to contain a requirement that the beneficiary worked on an engagement that requires an individual of O-1 caliber, but the current version does not include that language. However, that language was left in the context of additional engagements that do not require amended petitions. Is his understanding correct? Who should make the determination of O-1 caliber? The agent, the prospective employer? Does anyone want to share their thoughts on that topic?
The requirement is actually, I believe, that the services rendered require someone of O-1 caliber, something to that effect. I can't quite remember what the original language was, but in any event, it was removed in some places, and INS at the time simply forgot to remove it from elsewhere, and that there is no additional requirement there. And to my knowledge, the agency has never imposed it after having removed most of the language to start with.
That being said, I think, and I'd be interested what the rest of you say, but I think that there's a good faith aspect to this, that when I have a client who, for example, got their O-1 as the first chair violinist in a major orchestra, and then wants to take a gig teaching music in a kindergarten, I'm like, well, I think that's outside the scope of what your O-1 was for. I don't know how that, within the existing legal structure, I don't know how to actually to say that is illegal, this is not. But there's somewhere along that continuum from being the first chair violinist to being a kindergarten music teacher that I think we've dropped off the good faith place. And I would have to counsel my client with that. I wouldn't be comfortable with that. Do you guys agree with that?
I do.
Yeah.
Similar services is the issue.
Absolutely. All right. Well, we're a bit over on time, so I think we're going to have to wrap up for today, but we thank you very much for your engagement and for joining us, and we will be sharing the recording and the slides from this presentation, and we hope to see you all either virtually or in real life soon. Have a great afternoon.
Bye all.
Bye-bye.